Hi, my name is Alex Dolphin. Welcome back to another episode of Ex Ante. Today, we're going to discuss the case of Martin versus Herzog. This case was argued in the New York Court of Appeals in the year 1917. Martin and Herzog got into an old school car accident. And I say old school because Martin wasn't really driving a car, he was in a horse-drawn carriage, and Herzog was driving a very early version of a vehicle. Herzog, it was late at night, and Herzog rounded a corner. When he rounded that corner, he struck Martin's carriage. Martin's carriage didn't have any lights on it, whereas Herzog's vehicle did have lights on it. It was currently a statute in the state of New York that required all vehicles operating at night to have lights on them. So Herzog was compliant with that statute. Martin was not, because his horse-drawn carriage did not have any lights. Unfortunately, in the accident, when the vehicle struck the horse carriage, Martin was killed in the accident. So his family was obviously not pleased, and they brought suit against Herzog, claiming that he was responsible for the death of Martin. So the lower court ruled in favor of Martin and held that, because Herzog struck him with his vehicle, he was negligent in doing so, and he was responsible for the wrongful death of Martin. So Herzog wasn't pleased with this, and his attorneys went and appealed the case to the higher court, New York Court of Appeals, and that's the decision that we're going to discuss today. The issue at hand is whether breaking New York highway law is prima facie evidence of contributory negligence. More generally and more broad, it would just be whether breaking a statute is prima facie evidence of contributory negligence. So, and by prima facie, I mean on the face of it. So if you break a statute, are you automatically held by the court to be contributorily negligent for whatever wrong happens when you're breaking that statute? So let's go ahead and jump into the ruling of the New York Court of Appeals, and it was not in favor of Martin, it was rather in favor of Herzog. They overturned the lower holding of the trial court and held that because Martin didn't have lights affixated to his vehicle, that he was indeed contributorily negligent. That's because he was breaking the New York statute that required all vehicles operating at nighttime to have some type of light affixated to the front of them. So Martin probably wasn't pleased by this, neither was his family, because they didn't get to recover. They remanded the decision to the lower court. A bit more about the general justification of the ruling. In the decision, it states that the jurors shouldn't be given discretion in how they wish to apply the law. The law was passed by the New York State Legislature, and it held that if anyone was driving a vehicle at night, operating, I guess is the better word because it's a horse-drawn carriage in one sense, that they needed to have lights affixated to them. Because Martin didn't have that, the court held that he was prima facie contributorily negligent for what had happened to him, and it didn't allow him to recover in the way that he had hoped to. All right, so let's go ahead and jump into some of the ex ante implications of the precedent set in this case. The precedent being that if someone is breaking a statute, it can be held that they are contributorily negligent for any wrongs that occur to them in the future. So the first one I want to consider is someone who has their license suspended for whatever reason or another. Their license is suspended. Let's say that person is still driving a vehicle. They're driving a vehicle down the road. Nothing is wrong. They run through a green light, and someone runs a red light and T-bones them, severely injures them, and causes severe harm to this individual that was driving with their license suspended. Well, because this person that was driving with their license suspended was technically breaking the law when he was hit by this individual, could this individual raise a defense that this person was contributorily negligent because they didn't have their license? And if the court ruled in favor of that type of a defense, I think that would be very unintuitive. That wouldn't make us feel good, because driving without a license doesn't seem to preclude any opportunity that you should have to recover against someone who actually hits you in a completely negligent disregard for your own life running a red light. So that's first scenario. Another one would be, some people ride buses for free. They bus hop and they don't pay the tickets. They don't pay the fare when they hop on the bus or the subway. Consider an individual who hops on a bus, doesn't pay the bus fare, and then when that bus is driving down the road, the bus driver falls asleep at the wheel, runs off the road, and severely harms or injures the individual that was riding on the bus without paying for their bus fare. Because that person didn't pay the ticket before they got on the bus, they broke the technical statute. and they were technically stealing from the public transportation company, could the public transportation company's attorney raise that type of a defense against any suit of negligence towards them? They could say that, well, he was contributorily negligent because he was riding the bus without paying for a ticket. That's another scenario I want to envision. I think we would like to see a world where that person driving the bus could recover against the bus company, but under the precedent here in Martin versus Herzog, I think the defense would have a very good defense saying that they were contributorily negligent. So let's jump into the third ex ante scenario that I want to discuss in the final one, jaywalking. How often do we all jaywalk? I've jaywalked. Many people have jaywalked before, especially in busy downtown streets when traffic is slow. Let's envision you want to jaywalk across to go grab your lunch really quick. So you run across the street, and while you're doing so, someone doesn't look to you at all and completely just annihilates you, right? Say this is a busy street with a lot of people walking. He's going 60 miles an hour down Main Street, comes through and just completely knocks you off your rocker. You get severely injured, break both your femurs and your hips. So you'd like to recover because this person hit you. Well, his defense could very well raise the claim that you were breaking the law. You're contributorily negligent because you were jaywalking in this scenario. It might not seem intuitive, especially in a scenario where it's a busy street and that person should have been driving more slowly. However, it is very possible that the defense could be raised that you were contributorily negligent because you were breaking the law technically as you were jaywalking. Even something so innocent as jaywalking could be construed as contributory negligence. So that's all I wanted to run through. Thanks so much for watching. If you have any other ex ante implications, feel free to leave them in the comments below, and I hope you have a nice rest of your day.